Good evening, folks. I see some of you are signing on. We're just going to give you a couple of minutes here to sign into the webinar. We're going to probably start about 6:02-ish. So come on. You could probably see a blurry picture of me. Sorry about that. And a handsome picture of Samuel Bryant. I think it's probably the same in real life. I would be blurry and he would be handsome. So, yep. So come on. We're going to take a minute or so here. Everybody signed on. For those of you that are just coming on, we're just going to wait a minute or so, and we will get going. We have almost a couple hundred people signed up, so just give everybody a chance here. My name is Rich Morgenstern. I am the chapter chairman for webinars for SCORE. Oh, we already have a question. How can we have a question already? Let's see.
I think it's a comment. Thank you, Rod.
You guys look great. Woohoo! Who's that? Hey, Rod. Thank you.
Thank you.
Thank you, Rod. Yeah, folks, just going to give another minute and we'll get going so everybody can hear the whole presentation. All right, just about ready to get going here. All righty, I think we are ready to go here. I apologize for those of you that are looking at a blurry picture of me. I recently transported this computer and it might have got damaged in the transportation here. So let me see. We're going to get a little chat here. Let me see what's going on in the chat. All right. Probably people are telling me that my screen looks blurry. Let's see. Great work. Great work, Jim. I like Chairman Morgenstern. I like this. Explain acronyms. Okay. Okay. Don't use too many. If you use acronyms, Samuel, let's tell people what they are. All right. So anyway, so good evening, ladies and gentlemen, and welcome to Corporations and Contracts Must Know. This webinar is sponsored by the City of Oakland Park and presented by a longtime and one of our most popular presenters, longtime SCORE volunteer, Samuel Bryant, attorney at law. I'd like to offer a special shout out, as always, to our military, our first responders, and the people who have been so important in our first line defense against COVID. Thank you for all that you do. Okay, I'm going to give you an overview of SCORE. I am I'm the chapter chairman for webinars. We put on over 250 webinars a year with over 10,000 attendees and all sorts of subjects. For more information about our webinars, as always, go to broward.score.org, where you find all sorts of information, as well as you can sign up for your always free mentoring. We will not have a message from Caitlin Kyler from Oakland Park tonight, from the Oakland Park Community Redevelopment Agency. That's opcra.com. They're the sponsor. If you're interested in doing business in Oakland Park, they are an excellent place. They're very business friendly. We're going to introduce Samuel Bryant, our expert speaker for this evening, and on the webinar, Corporation and Contracts Must Knows. As we go along, hit the Q&A button or the chat button, and we'll answer as many questions as we can that are pertinent to the group as a whole. Who is SCORE? We have a very successful chapter here in Broward. We're a diamond chapter, one of only 10 in the country. We have 70 volunteers from all lines of business: manufacturing, distribution, not-for-profit, legal, accounting, you name it. You could find a mentor that has 30, 40 years of experience that'll help you with your challenges and opportunities. I myself used a mentor in my first business in 1990. That person actually helped turn a business that was doing hundreds of thousands of dollars into millions of dollars. Thank you to my first mentor. We will start be doing face-to-face webinars again shortly. The sessions use about 45 to 60 minutes. They're usually done by Zoom. Like I said, well, they'll be in person soon, or they can be done over the telephone. Tell the mentor what your challenges and opportunities are. We have a 90% satisfaction rate. We cannot profit in any way from your business. We can't invest in your business. All we can do is help you. These are successful business people from all walks of life that are looking to give back. So take advantage of it, broward.score.org. You'll see a sign at Broward, a screen that looks like this. Make an appointment. There is never a charge. All right, you can either schedule an appointment or have a mentor contact you. This webinar is being recorded. You will receive a copy of the PDF as well as a link to the recording. As I said, this is sponsored by the City of Oakland Park, a very business-friendly community. Here are some of the things, the webinars that we've done with Oakland Park and some of the ones that are coming up. Obviously, tonight's corporations and contracts. We have Plan Your Website, Small Business Human Resources. For Hispanic month of August, we have Knowing and Learning About Your Competition. September, Creating a Brand, all very popular seminars. They're probably not available on the website yet to register for, but they will be shortly. As with all of our webinars, we do not expect you to walk away with a Master of Business Administration, an MBA. But if you could pick up and learn 2 or 3 instantly actionable items to help your business, you are way ahead of the game. So go to broward.score.org. At this point, I'd like to tell you a little bit about Sam Bryant. He was a corporate lawyer. Sam counsels business owners on entity formation and helps identify any legal issues that present themselves throughout the business life cycle. He has experience in drafting, reviewing, and negotiating operating agreements, partnership agreements, non-compete, and franchise agreement. Sam also provides ongoing legal advice to businesses of all sizes to help them navigate state, national, local laws, rules, and regulations. Sam was instrumental in making the business community aware of the legal issues surrounding COVID during the past 18 months. He gave some of our most popular webinars, and he helped out hundreds and hundreds of people. At this point, I would like to turn it over to Sam Bryant, who is going to present tonight's webinar. Sam, it is all yours.
Thank you, Rich. If I could blush, you'd see me be all red. That was a very great introduction. I appreciate that. Let me just share my screen. Oops. All right.
Folks, as you might expect from an attorney, the first line is going to, the first screen is going to be a disclaimer.
Always have to cover my bases. The Florida bar, you can never be too careful. That's one thing that I've learned. So just so you all know, this workshop is being provided solely for informational purposes and does not create an attorney-client privilege or provide advice for any individual situation. This workshop should be used in conjunction with and not as a substitute for qualified legal counsel. Only an attorney with knowledge of your situation can provide the assistance you need. You are urged to consult an attorney about your individual matters. So basically, we are here to educate you. If you have general questions, please feel free to ask. I would like this webinar to be as interactive as possible. I think I hated learning about contracts in law school, but love practicing law with contracts. It's a very interesting endeavor. So if you have general questions, I'll be more than happy to answer them. But if you have a very specific question about your specific situation, we can't discuss this publicly, but you will get an email address that you can email. We'll have access to that at the end of the presentation. And I'd love to have a one-on-one chat with you if you have any specific questions.
I am actually going to put the email address on the chat right now. So, and I'll probably do a number of times during the webinar. Okay, Sam?
Okay, perfect, perfect. So in this webinar, you're going to learn several things. Like Rich said, I'm not here to teach you to be a lawyer. I'm just here to give you a perspective from my experience on how business owners should approach their contracts and some little things that you can be aware of. And there will be some actionable things that you could implement immediately that I feel will help your business establish a great legal foundation when you're interacting with the public or people within your organization. So we're going to first discuss what makes an agreement a contract. There is a difference between an agreement and an actual contract, so we'll discuss that. The basic contract that every business should have. I know that every situation is different, but what it comes down to is that basically every business contract is rooted in the same fundamental principles. So we'll discuss the basic contracts that establish that legal foundation. The one provision that should be in every business contract, we're going to discuss that. And this is my opinion, but based off of my experience, this one provision will save you thousands of dollars if you have a business contract. What is boilerplate contract language? I believe most of you should know, I believe most of you have heard that term boilerplate. We're going to discuss what exactly does that mean and what provisions, what effect those provisions have on your contracts. Number 5 is a very practical idea, how to properly use online contract templates. I recognize that not everyone can afford legal services at certain points. It can be very expensive. So online contracts are usually somewhere, or at least online is where people kind of go to form their contract. So we're going to teach you some best practices on really how to use that and what the implications are of using those incorrectly. Then we're going to just wrap up with some best practices for enforcing contracts. There is a difference between having a valid contract and having an enforceable contract. So we're going to give you some best practices that you can take away from here once we learn about that. So what is a contract? Let's just start by a basic definition. I'll take this from Merriam-Webster: a binding contract between 2 or more parties. Very simple, but there's a lot to unpack. So I have my own definition of a contract according to Florida law: a legally enforceable agreement between parties where there is an offer, acceptance of that offer, and consideration between the parties. So those are 3 distinct elements that make a contract. And so we're going to flesh those out and learn about that, but that's the essence of a contract according to Florida law. And a little note here, contracts can be written or oral. So as a business owner, and when you interact with your partners, your employees, or the general public, you are engaging in conversations that could lead to legal obligations. So just because something is not written doesn't mean that you're not forming a contract. So why do we even need contracts? I think in an ideal world, I think a lot of business owners could just say, why don't we just have handshake deals? The problem is handshake deals can't be trusted. Contracts are basically a memorial of a handshake deal. Because people have faulty memories, things change, or people have nefarious intent, contracts are there to protect you so that if anything ever goes wrong and you have to go to court, you have proof of what your understanding was of the agreement. We need contracts because deals are very uncertain. It's easy to think that whenever you're engaging in any type of deal as a business owner, as long as I have the price and the obligations laid out, I don't have anything to worry about. There are over 1 million lawyers in the state of Florida, and a lot of these lawyers who practice business law are in business because of uncertainty. No matter what language you have in a contract, I will guarantee you a lawyer will find a way to make multiple meanings of one particular issue. So contracts help eliminate as much uncertainty as possible. And so because of that, contracts are never cut and dry. And so because of that, we really just need to have we need to do the best job we can to really make sure that both sides of an agreement have a clear understanding of their legal obligations. So I mentioned before that there's a difference between a valid contract and a legally enforceable contract. A legally enforceable contract has these 3 elements. And when you have these 3 elements, if you ever have to go to court, your contract will hold up as long as you have the 3. If your contract is missing one of these 3 elements and you have to go to court, your contract may not hold up, meaning a judge may not find it enforceable, meaning that you may not get, if you're losing money, you may not get your money. If there is an obligation that another side promised to you, they may get away with it because you don't have one of these 3 elements laid out in your contract. And so the first element is an offer. Parties must be given an opportunity to enter the agreement. So in essence, they just must be given a chance to say yes or no. Acceptance. It must be clear that the parties are agreeing to the terms of a contract. I think as business owners and just in general, I think these first 2 elements are pretty clear cut as far as the understanding of what does it mean to have an offer, what does it mean to accept it. So if you're a contractor and you have an invoice, your invoice can be considered an offer. And if you have your client sign that invoice, that can be considered acceptance. This third point is the point that I think a lot of people may have a difficulty understanding, or there's a lot of litigation over this particular point. There must be something of value exchanged between the parties. It can be money, it can be services, or it can be promises. The point here is, even if you have an invoice that's signed and is accepted, if it's not clear that something is being exchanged for something else, you may not have a contract. So I want to take a minute to kind of apply what we've learned so far. Take a moment to read this scenario. I'll read it aloud to give you some time. But basically, we'd like to open it up to the group to see, based off of the information given, if you believe that a contract was formed. So his first scenario, Bob is a contractor. On Sundays, he visits his friend Tim's house to watch football games. While Bob and Tim are watching the game, Tim complains to Bob that he thinks the pipes in his guest's bathroom are leaking. Bob then pops up and runs into the guest's bathroom. Tim thinks Bob had an emergency, but finds out that Bob actually fixed the leak. Tim is pleasantly surprised and thanked Bob for his work. The next day, Bob emails Tim a bill for $500 for fixing the leak. Was there a contract? So I know there's a lot of information here, but given this scenario, do you think a contract was formed, or do you think there is no contract? So it looks like so far I'm getting some no's here. Some no's. Is there anybody who thinks there was a contract formed? No contract.
Hey, Samuel, why don't you really tell the truth? Wasn't it really a lawyer that ran into the other room and wanted to charge the $500?
Hey,
You're defaming you're defaming plumbers here.
hey, if that was a lawyer would have charged a lot more than that.
It looks like people are saying no contract.
All right, yeah. So we don't have a contract here, and I believe I think a couple people pointed the exact reason why. Bob and Tim don't have a contract because there's no offer. Bob ran into the bathroom and he faked leave without asking Tim, so Tim never had an opportunity to say yes or no. But if I was there and I was Bob's lawyer, maybe I could argue that Tim benefited from my services and that there should be a contract, or that there's an implied offer if Tim doesn't form any type of objection, if he just lets me walk off. So there's no contract here, but it could be possible that an argument could be made in court that it's enforceable depending on what happens next. So let me just twist up the scenario a little bit. What if Bob came out of the bathroom and wrote an invoice to Tim, and then Tim signed the invoice for the $500? Would there be a contract at that point? Because now Tim sees it, he sees the invoice and signs off on it. So I'm getting a lot of yeses now. Yes, because it's an agreement. Yes, okay. So it sounds like there's a consensus that even if the services were provided first without Tim knowing, the fact that he retroactively consented to it, there's a contract. So it makes it more of an agreement. But if I were Tim's lawyer, I could argue that yes, there is a contract here, but maybe it shouldn't have been for $500 because I was coerced into signing this because the work was already done. I don't want to get too complicated with the scenario, but contracts are meant for agreements for work to be done in the future. Tim foolishly signed. Yeah, that's a good point. When performance is done before an agreement is formed, so basically if you perform and then retroactively get someone to sign something that said they're going to perform, that may not be a contract. If you perform something and then you get someone to sign something that says you performed something in the past, that may or may not be a contract. As a lawyer, I can twist up scenarios to make a clear yes or a clear no a definite maybe. And that's where lawyers make their money. So you can see that a scenario can start out one clear way, but if there's an issue, something that seems clear cut becomes very complicated. Let me ask you guys another question. What if Bob takes the invoice from the bathroom? So let's just pretend that Bob never did the services at all. So let's just say that Bob runs into the bathroom, tells Tim, you need to fix your pipes. I can fix it for you. Gives Tim an invoice for $500. Tim scratches out the $500 and writes $400 and then signs that and gives it to Bob. Is there a contract formed at that point in time? So again, Bob hasn't performed the work yet, gives an invoice to Tim, says it's $500, Tim scratches it out, writes $400, and then signs it. Is it a contract? So I see a couple of yeses, I see no contract. Someone's asking, did Bob accept? Agreement. So it does seem like here, there's some gray area here. Imani Inc. brings up a good point. Did Bob accept? So the answer here is that's not a contract. The moment Tim scratched out that $500 and wrote 400, Tim made a counter offer to Bob. So by Tim signing that, all Tim did was sign an offer. Bob now needs to accept that offer. He could accept that by doing the work, or he could countersign that invoice, but there has to be some indication that Bob is okay with the new price. So I think you guys did, that was a great job of identifying that. So as you see, again, some very clear-cut scenarios can become very murky if you change a little detail here or there. I believe there is a question. I don't want to skip over it. So I think Milo asked, so by him telling a contractor about a problem that he could fix, if the contractor gave him verbal advice on how to fix it, can he still be compensated? So I mean, he could be compensated if Tim gives him the money, but if the question is if he gives verbal advice, does that form a contract? I'd have a hard time. There'd be a very hard time arguing that that is a contract, mainly because you could argue there's no offer. If you just blurt out some advice and then you charge somebody for that without giving someone the opportunity to reject the offer or not, then you're going to have a hard time demanding the money, establishing a contract. But if Tim wanted to do it out of the goodness of his heart, then he could give him that. He could give him the money for that advice. Exactly. If the other guy is kind enough to pay him, he could. But there's a strong argument to say that he doesn't have to. All right, let's go to the next scenario. Mary owns a pet store. She finds a space she loves and starts negotiating a lease for the space. The landlord offers a 5-year term. Mary accepts the deal and signs the lease. The landlord also tells Mary that if everything works out well, Mary will have the right to renew the lease for an additional 5 years. The renewal terms are not in the lease. Is there a contract for the renewable terms, the renewal terms? So I think a lot of you are in commercial leases, so this may hit a little bit closer to home. I'm sure you've all signed leases before, and I'm sure a lot of leases have some sort of, at least if it's not in there, some conversation about renewal terms. So it looks like only a verbal contract is not defined, no future contract, no. I believe we have a yes in here. It's oral. So it looks like, did Mary accept the renewal term? So there's some good points brought up here. So, but it looks like there's a general consensus that there's not at least the renewal terms aren't a part of the original lease, but it's its own separate oral agreement. Let's look at the answer. Oops. So it's probably not, because there is no consideration for the renewal term. Mary is paying for the initial 5 years. Mary would have to pay an additional amount separate from rent for the right to renew the lease at the end of the term. So this is where I talked about earlier, that consideration becomes a sticky issue in contracts. When you have the idea of a commercial lease, that initial 5-year term only covers that 5 years. When you start talking about things that happen after that 5 years, you're now outside of the consideration. The consideration that you're paying is the rent. As a renter, you are paying a specific amount of money to have the right to occupy the space for that amount of time. So any provision that deals with your occupancy after that 5 years needs its own separate consideration, which means you need to pay separately for that. You paying rent, your base rent for 5 years, does not give you a contractual right for an additional 5 years unless there's some separate consideration given. So your answers, I think there's a few answers that said that there's an oral contract with that initial lease term. So because there's no consideration for that lease term in general, there's not necessarily a binding agreement for that. But let's just pretend that there was. So let's just pretend that Mary actually ends up paying an extra fee for the right to renew the lease term an additional 5 years. Even then, this is a little quirk, but even then, that wouldn't actually be a contract, because in the state of Florida, any performance that takes more than a year has to be in writing. That's something that it's hard. I wouldn't expect anyone to really know that, which is why contracts becomes tricky, because there's little nuances here. But the main issue I want you all to focus on is the consideration. So when you're signing your contracts here, just because you have, let's just say in this example, a lease, and even if that lease ends up talking about renewal terms in it, and you see that all you're paying for is that initial lease term, you may end up having a big issue with enforcing that contract as a tenant if you haven't paid anything additional for that right to renew. So that's just something to really keep in mind here if you're signing your leases and not really thinking of, if you don't really know about that issue. So I want to ask you a little twist on the facts here. What if Mary emailed, or not Mary, what if the landlord emailed Mary the renewal terms? So basically, if Mary signs the lease and then that night the landlord emails Mary and says, oh, by the way, forgot to mention, here's this lease term in there, here's this extension, or here's a renewal for X, Y, and Z in an additional 5 years. And let's just pretend that the lease does provide for that extra consideration. So can that email be considered a contract for that renewal term? I see a yes. There's some thinking. I see a no. I believe so. But should be added to the contract as an amendment. Oh, I see. I see what you're saying, Rod. Right, you add it as an exhibit. I see. Or Rod, what if they've already signed it and then that night they're having the email? Are you saying they're retroactively adding the email as an exhibit? Is that what you're saying? There's no acceptance. Okay. So the answer here is it depends. There's not going to be a clear-cut answer here. It depends on what you want it to be. If you are married and you like the idea of the renewal terms, so let's just say there's an issue here. If there's a fundamental issue of the 5 years are up, and then the landlord moves someone else in, and then now they're fighting over the contract. They're saying that we have this lease that provided for an additional 5 years, and you emailed me this email confirmation basically saying that this 5 years applies to the contract. So if you're married, there is an argument that it is a contract because because Mary paid for that that extension, basically the right to that extension in the lease. The fact that the email came afterwards is just an explanation or a confirmation of what was already in the contract. If you're the landlord and you don't want to honor the contract, you could argue that the extension, the additional 5 years, is so much of an important term that Mary should have caught that in the contract. That if she didn't see it in the contract, then she's agreeing that it doesn't exist, basically. So, or what Mary's really paying for is maybe the right or maybe just the opportunity to, but the landlord doesn't have to honor it. So there's a lot of things in contracts that aren't cut and dry here, but as you get closer and closer to really forming these agreements, and the agreements get longer and longer and longer, and there's more conversations back and forth, you start to add a lot of ambiguity to it. I believe someone have a question?
No.
I don't think so. Okay. All right. Yeah, so I think you guys did a great job in these scenarios. It looks like a lot of you probably have a good understanding of contracts coming into this, because that was a great job. All right, so there are certain contracts that every business owner should have. Contracts are, you could consider it a form of art for some attorneys, because there's a whole lot of different contracts. You can name them anything you want to. What really matters is the actual terms in the agreement. For a business, I could argue that 95% of any contract that you're going to sign covers fundamental issues. It's the same fundamental issues every single time. It's just that you call them different things. You add different details according to your practice or your industry or who the person is you're working with. But there's certain fundamental agreements that you're always making, and they all branch out from there. So I kind of like to break it out into 3 categories of contracts that form a legal foundation for your business. So first, contracts for your product or service. It doesn't matter what you're selling, whether you're a service business or a product business, you are dealing in contracts. The major exception here is product businesses where, let's just say McDonald's, right? McDonald's is selling $5 cheeseburgers. They're still forming contracts with the customers. It's just that these are oral contracts that they're promising to provide a service, but they're providing it to you so fast and you're paying so fast that the transaction is over with in a matter of minutes. But they're still oral contracts. So for a McDonald's product, they may have a website, and that website may have terms and conditions about how your customers interact with the app or the website itself. So terms and conditions are contracts that any business that has a website or has some sort of technology should have. In service-oriented businesses, there should be service agreements between the actual company and your customers. McDonald's doesn't have to worry about written contracts with their customers because those transactions happen so fast. When you're in a service-oriented business and your services extend out for a longer period of time, or you're priced at a point where it takes a long time to finish your services, you want to have service agreements because things may go wrong. And when things go wrong, you want to make sure that you can show if worst case scenario you get sued, you want to make sure that you can show the agreement that the customer agrees to or that they signed off on. Whether you want to call them retainers, invoices, um, receipts, they're basically all elements of service agreements for your business. So you want to have contracts for people in your business. Employment agreements, you don't necessarily have to have employment agreements if your employees are at will, meaning that they can quit anytime they want, or you can fire them anytime you want. Employment agreements come in handy when you have executives or high-level managers joining the company because you want to tie certain obligations to them and secure their services for a certain amount of time. But if you're working with independent contractors, you definitely want independent contractor agreements. There's two primary reasons why you want independent contractor agreements. One is because it's just good business practice, because you are establishing a relationship, an ongoing relationship with no end date. So you want to make sure that you're not having any issues with people who could be fundamental in providing services or products for your business. The second reason is because you want to distinguish between having an independent contractor and an employee. A lot of businesses get into very hot water with the Department of Revenue when you have 1099s and they quit or you fire them and they make unemployment claims. And they claim that they should have been classified as an employee instead of an independent contractor. So independent contractor agreements will allow your business to specify that both sides have a clear understanding that the independent contractor is not an employee and there is no employee-employer relationship. One of the most important agreements that I believe that you should have in your business, if you have a business partner, is some sort of partnership agreement. Partnership agreements take different forms depending on if you're an LLC or a corporation or a partnership, but the principle is still the same. You should have a written document that governs who does what in a relationship, who has what equity, and what obligations you both have to the company. My practice is there's an element of forming contracts, negotiating contracts, but a big part of my law firm is representing business owners with legal conflicts and litigation. And the vast majority of the conflicts that we represent business owners in are partnership issues. When you don't have a partnership agreement in your business, I will guarantee you that if you end up hiring a lawyer, that you will end up paying, if you're lucky, at least $10,000. If you have to go through trial, you're paying six figures. So if you're going to litigation within a partnership dispute with someone else, with your business partner, it could cripple the business, it could end the business. I've seen both. So you want to make sure that you have an agreement established so that if there is ever an issue, it gets nipped in the bud as soon as possible. And that's the name of the game. So that's why my opinion, I think those are the most important contracts that you should have if you have a business partner. The third category of contracts you should have are for people outside your business. So these are people who you're not serving, but they work with you. So vendors, suppliers, your lease agreements, which the vast majority of you, I'm sure, have signed. If you have investors, if you're going through private lending, for these specific agreements, you may not have these internally. So basically, you may not be drafting these agreements and giving these to other people to sign because typically these are bigger companies. Then they may have you sign their agreements. But whenever possible, you do want to have these agreements that you can just give to other businesses and have them signed so that it's 100% clear that you know exactly what you're obligated to do because you're familiar with the contract. And if they countersign it, then you have an agreement that you're familiar with instead of signing a bunch of things that become foreign to you and that you may or may not understand.
Hey, Sam, before we, just a quick, couple of quick questions here.
Sure.
Rosario asked, in the United States, do contracts need to be in English?
They don't need to be in English to be enforceable. So you don't have so basically you don't have to have a contract in English. What happens is it creates a lot of issues if there is a disagreement and you have to go to court and you're dealing with an English speaking judge and English speaking jurors who may decide your fate. The reason why I say it can cause issues is because my wife is so let's just say Spanish, for example. My wife is Hispanic, and she tells me that there are certain concepts that aren't easily translatable from English or Spanish to English, and it's very prevalent in business. So there's a lot of business concepts in Spanish that may not be readily translatable in English. So when there's issues over interpreting a specific provision, it can cause a lot of issues. So I think the best practice is when dealing with um, business in Florida, and you are a Florida business yourself, the best practice is to have those contracts fleshed out in English, and they can be translated to Spanish if you have a bilingual attorney. But the best practice is to have those signed in English so that there is ever an issue, you don't have that translation issue in front of a judge and jury.
Good. That's a great answer. Thank you.
Okay. Um, so attorney's fees. This, to me, is the most important provision. Not the most, but it to me, it's a provision that should be in every single contract you ever write. Even if you're a contractor and you have just simple invoices, you need to have some attorney's fee language in there. Attorney's fee language just basically states that if there's a violation of the contract and the parties must go to court over the violation, the losing party must pay the winning party's attorney fees. Because this contract can be included, or because this provision can be included in any contract, I believe that it should be. Because what's interesting about this is all you have to do is collect a single dollar as the winning party, and the losing party has to pay all your attorney's fees. So why is this, to me, one of the provisions that has to be in every contract? It increases leverage. The one thing that I hate seeing when I have people come to me asking for help is someone telling me I have an issue with another person, a partner, or somebody else, and let's just say $3,000 is on the line, basically. So somebody stole $3,000 from my business bank account, or somebody owes me $3,000 and they're not paying me back, and I've lost contact with them. I don't know what else to do other than sue them. So they're looking for legal representation, but either there's no contract or the contract that they have has no attorney's fee provision. It's hard for me as a lawyer to take on that case and help because I know it's going to cost more than $3,000 for you to recover your $3,000, even if you are 100% in the right. So having an attorney's fees provision increases your leverage, because if the wrongdoer knows they did wrong, or even if they think they were right and you actually pursue them, they have to make a decision on whether or not it's worth going to court, because if they lose, not only do they have to pay your damages, but they're going to have to pay your attorney's fees. And if you have to go all the way through trial, like I mentioned before, a lot of business litigation cases are over 6 figures. So even if you have a $2,000 issue, they may end up paying over $100,000 simply because of that provision being in the contract. So as a result of that, it encourages early settlement. Again, I'm assuming that you're dealing with someone who's a rational thinker. A lot of times emotions get in the way of legal issues. So, it may not be always a given that that the other party would want to settle, but logically speaking, it makes sense. If you know you did wrong and you know that this person's going to sue you, the risky proposition is to go to court. The best economic position is to find out a way to negotiate this so that there's less at stake if you have to keep the issue going into litigation. So this makes litigation a feasible option for that person. It's for the person who may not have a lot of money at stake in the grand scheme of things, but it's enough money to want to pursue. And it's mainly because most attorneys or more attorneys will be willing to help you. So if you come to me and there is no attorney's fee provision in there, I'm less likely to be able to help, even if I believe in your case, because out of good consciousness, it's really hard for me to justify advising you to go through with litigation if I know that no matter what happens, you're going to end up losing money. I never want to put someone in a worse position for hiring me than if they didn't. And it's a hard thing to tell people, because even if the legal issue is $3,000 is a lot of money. So if you have an attorney's fee provision, an attorney may be more likely to take you on, because the attorney now knows there's a prospect of me getting my fees on the back end. So I may be more willing to maybe charge you a nominal amount on the front end to get the work started, and then take my fees out of the final judgment if we get that far. And if you have a lawyer, you're more likely to get your money back. So it makes an attorney's fee provision just basically opens the door to you finding your solution if anything goes wrong. To get the benefit of all of this, you have to draft it correctly. So, the basic idea of an attorney's fee provision is that the winner of the lawsuit gets their attorney's fee paid by the loser, but it's a little bit more nuanced to that. I just want you all to understand that in every contract that you're forming and drafting, that attorney's fee provision can be a very powerful tool for you to use.
Good question, Sam. Milo asks, where should contracts be stored and how long do you need to keep them?
I'm sorry, can you repeat that?
Where should contracts be stored? Milo asked this question.
Uh-huh.
Where should contracts be stored and how long do you need to keep it?
Okay, yeah, so that's a good question. So I believe the best practice is to have some sort of electronic form of the contract. Now that we're in more of a digital age, the laws have actually changed a lot. So you don't need the original form of a contract in order for it to be enforceable. So the best practice is when you get a contract and you have someone sign it in person and you have this paper, scan it into your computer. And ideally, your company will have some sort of database where you hold your important paperwork and have a backup of that data, so that if there's ever an issue that arises, you can always pull it up electronically. And an electronic form is just as good as an original form. What's even crazy is just, and as a matter of fact, it's now so flexible where you can email someone a contract with two signature blocks. So for your signature block and the other person's signature block, if your signature block is signed and you send it over to the other, and the other side sends you back the contract with their signature signed and yours isn't. So basically, the idea is if you both have a blank contract, if one person has their signature and then the other person has their signature, so basically there's no form that has both signatures, but there's two forms that have one signature, that's still considered a valid contract as long as you have both forms. So just to answer the question, is to summarize the answer, um, you should have an electronic version. The second part, how long should you keep it? You should keep it as long as that relationship exists. I would even say if you can have an electronic database, just don't ever delete it. And if it comes to an issue of space, then you just work from your oldest contracts to your most recent. But my advice would be just create some sort of electronic database and then just have all of them there. So that if you ever have to pull it, you'll have an electronic form.
So I'd like to add something here. Having done dozens of contracts throughout my business career, and the importance of this attorney fee thing is that you cannot prevent stupidity. With the most well-written contract, with all the dots and all the T's crossed, you cannot prevent somebody from saying, "I don't care, sue me."
Yeah.
And so this is extremely important. I've seen it many times. You cannot prevent stupidity. Have the attorney fee in there for the other party.
So that's an excellent point, Rich, because one thing that I tell a lot of my clients is no matter what we do, a contract is a form of insurance, basically, if you want to look at it like that. In an ideal world, you'll never have to look at it ever again after you sign it because the business relationship is going well. But if something goes wrong, you have something to fall back on. Mainly because no matter no one. So basically, I tell my clients, anyone can sue anyone for anything. Florida gives anyone the right, the access to the courts. So it doesn't matter if I make up a complete story about our relationship or your business, I can still get into the court system to sue you to the point where you have a process server knocking on your door and hand delivering you a lawsuit, forcing you to respond to it in 20 days. The idea here is the contract. If that happens, the contract gets you out of court as soon as possible and limits the amount of money that you have to spend, or prevents you from even going to court in some scenarios because you built in language that tells the other side that if there's ever an issue, we have to mediate it first. But the point here is anyone can sue anyone for anything. The question is, how fast can you get out of the lawsuit? On the other side, if you need to sue somebody, how fast can you get your resolution? A contract speeds up that process.
Quickly, thank you. Cecilia asks, can one of the forms of the contract be a copy from the original?
Yes, as long as it's a true copy. So basically, if you have the original and you're photocopying the exact same thing, you can do that. Let's just say if you have the contract formed and it's signed and countersigned, but there's a provision missing, and you photocopy that and then you write in provisions afterwards, that's not okay. That's not valid. The only way it becomes valid is both sides would have to re-sign that. So as long as you're making a true copy of it, that is acceptable.
Great, thank you.
I'm hesitating to bring up this point to that question. I don't want to get too nuanced, but there is a technical rule that says if you ever had to go to court, they call it the best evidence rule, which would basically mean that if the original is available, you should use that, and you should only use copies if you can't find the original. But just because it's a copy doesn't mean that it's not a valid contract. I hope that makes sense.
I think so.
Okay. So let's talk about boilerplate contract language. I assume that some of you have heard about the term boilerplate. I know I did before law school. Never really cared to know what that really meant. But now that I'm a lawyer, boilerplate language is basically the provisions that are found in, I say every contract, but they can be applied in every contract. I think that's a better way to say it. It can be if there's language that can be applied in every single contract that ever exists. So, but it doesn't necessarily mean that they will be in every contract. I call it cut and paste provisions for attorneys. And it's not because boilerplate language is irrelevant or it's not important. We call it cut and paste language because of the fact that it can be applied in any situation, any and every situation. So I have some examples here. Choice of law, that just dictates where the party will litigate a dispute. So one little interesting fact here is that even if you sign a contract in Florida, you have the flexibility to apply any state's law to that contract. So if you're in Florida, the other party's in Florida, but for whatever reason you like California's laws better for, for, I don't know, some states do differ with different issues. You can state in your contract that if there's ever an issue, California law dictates the contract. So that gives you an example, because if you bring a contract to me as a Florida lawyer and I see that there's a choice of law provision in there that says that California governs the document, I'm not going to be much use of, I won't be much use to you because I'm licensed in Florida. I would have to direct you to talk to a lawyer that's licensed in California. Severability. If one provision of the contract is deemed unenforceable, the other provisions are still in effect. This becomes very important with non-compete contracts. So if any of you have partners, or if you have employees that you have them sign non-competes, this becomes a very popular provision, because what courts will do with non-competes is if there's an issue, a court will literally retroactively say, they will cross out language in your contract and say, I know that you said this, but we're going to pretend that you meant this. And now this is what the contract is going to state. Or they're going to say, this part of your contract is not enforceable. So a severability says, what it means is, in case that happens, if one part of the contract gets crossed out from a judge, it doesn't invalidate the entire contract. Every other part of the contract is still enforceable. This is a very good provision to have. It kind of goes back to our example with Lisa the baker. Contracts cannot be modified or amended without the consent of each party. What I should also have in here is, a lot of times the amendment will say that the contract cannot be modified or amended without the written consent of each party, so that you leave the ability to amend terms of the contract, but there has to be written consent that these terms are modified. So that kind of gives you that flexibility to add on terms to clarify certain points, or if circumstances change and you want to retroactively change terms of the agreement, then you are allowed to do that. Merger integration. This basically will state that any terms that are not in the contract are not enforceable. So you can kind of see how some of these provisions can work with each other. So if I have a merger or integration clause in the contract, and I am stating that any terms that are not in the contract. So if there's a term that is not contained in this agreement, it's not going to be enforceable. There's most likely there won't be an amendment provision in there or a modification agreement in there, because you're already stating that the four corners of this contract contain every single provision, every single agreement of the contract. Anything that's talked about afterwards or before or outside of this is not going to be a part of the agreement, and we're already agreeing to that when we sign. Do we have any questions? So I think I saw something pop up.
I do have one question here from Jessica. Are there any considerations we should think about if we were in the U.S. and the client is located and headquartered in another country?
Yes, Jessica. So, choice of law. So if your business is based in Florida and you're dealing with clients internationally, your choice of law is going to be, you want it to state that you're choosing to apply Florida law, and that if there's any dispute, it's going to be handled in a Florida court. Now, again, that's the best way to handle that. How does that play out in a practical sense? You know, if you have an international client that signs something like that and you have to sue that person, it can be done. You can sue someone internationally and pretty much drag them to Florida, but you're looking at a tough road of actually getting there. But that's more of a practical consideration as a business owner and a risk of doing business with clients overseas. But as far as a legal matter goes, you have that ability. If what happens is, if you don't have a choice of law provision in there, so there's no language that says what law governs the contract, or there's no language that says where are you going to litigate the dispute, what happens is the other side can basically take the choice out of your hands and say, we want to litigate this in federal court, which has its own set of rules and limits the attorneys who are going to be able to handle your case, because there are a lot of attorneys that, quite frankly, don't like litigating federal cases. So without saying too much and getting too much into the weeds about that, in your scenario, the choice of law provision would solve that issue. Okay. So, internet contracts. I recognize, as a business lawyer, especially for those of you who are starting your businesses from the ground up and expenses are tight and you want to really spend time on the business and not necessarily paying a lawyer a bunch of money to form your contracts, the internet becomes an attractive source to base your contracts from. So I take a position that a lot of lawyers probably may disagree with me about, and it's mainly because some lawyers see it as, well, if you let clients use contracts off the internet, then they're not going to go to you for the contracts. My position is, if you're in a position where you have no money, I'm not going to advocate you spend a whole bunch of money on a lawyer. What's most important is you get your business ready, because if you spend a whole bunch of money forming contracts and you're not making any money, then what are you protecting? So build something first and then protect it. So if you have to use an internet contract, it's better than nothing. But I want you all to just use them correctly, because the first lesson I want you to understand is, I'm not telling you that if you have a multi-million-dollar company, it's okay to use all your contracts from the internet and not use a lawyer. I'm just saying that from a practical sense, at the beginning stages of your business, you can use the internet as a tool. So use it as a start, but you want to get to a point where, if you have enough money, you have an attorney look at it, because the attorney is going to be able to turn around a contract that you can feel confident in. I don't care how much research you do. And quite frankly, you can't tell me as a business owner that you're sitting here researching hours, um, to use a suitable contract. I'm pretty sure you're spending a couple minutes. So for those of you who have internet contracts, it may not bite you yet, but it could bite you very big in the beginning. So it's kind of something where I kind of say, use it for a little bit of time until you have some money, then have an attorney come in and they can clean it up and then give you something to use going forward. This last point here is beware of the choice of law. And I say that because I've seen scenarios where people do follow this advice and they do bring me contracts they use online. And now they say, I have enough money to use a business attorney. So can you take a look at these? Or they'll come to me with an issue and they say, I have a contract. I didn't use an attorney. So here's the contract and I want to enforce it. So I've seen contracts where basically I'm looking at it and yes, they found, and it's obvious to me that they found it online. And then I read a choice of law provision and it says that this contract is governed by California law because they went on Google and they probably saw a contract from some sort of corporation or business that was based in California. And they did, and then the business owner just copy pasted it and had someone sign it. So now you're in a position where you can't have a Florida attorney, or at least a good attorney will tell you in Florida that it's not advisable to use me. You need to use someone else who practices in that state. So that's where it kind of really, it bites you. So if you have to use an internet contract, don't blindly copy and paste the information. At least read it. If you don't understand it, then that really is a sign that you may really need an attorney. My advice is if you can't afford an attorney, you can at least afford a database. There's a lot of databases out there where you can pay a couple of $100s to get something that's bare bones. At least you have a professional company that is giving you something to work with. It's not the most ideal case, but it's better than using it on your own. So if we think about a hierarchy, you paying a nominal amount for a database, well, a business attorney is going to be first, right? Ideally you would have an attorney form the contract for you. If you can't afford that, at least spend a couple of hundred, maybe $100 or whatever the prices are to at least search through a database and download a template from there and use that. If you can't afford $100 or so, and you just have no money whatsoever, I don't like using contracts that are free because that's where you get what you pay for. But something is better than nothing. So if you have to use it, then go ahead. But as soon as you get money, then use the database, and then as soon as you have enough money, use an attorney.
Sam, I have to admit, you shook me up a little with something you just said. It brought me back to my youth. The statement was, if you can't afford an attorney, and in my youth, that was followed by, one will be appointed for you.
Oh.
So you shook me up a little with that.
Yeah, and unfortunately, it happens. I mean, I'm not a criminal lawyer, but I mean, you look at, if any of you are any fans of like these crime docs, and you see these documentaries about people who are wrongly convicted of murder, if you actually do a study, I would bet my hard-earned money that more often than not, these defendants were represented by public defenders, which basically means they're not paying for their lawyer. The ones that are able to pay for the lawyers are the ones who are getting the better defenses. It's not a knock on public defenders. It's just public defenders are overrun, and there's not enough time in a day. When you're paying for something, you are paying for a professional to take the time necessary to advocate for your interests. And it's very hard for public defenders to do that. And it's very hard for you to expect them to do that because you're not paying for it. When you are paying for it, you can expect more. So, but yeah, it's very unfortunate, but yeah, at the end of the day, you do get what you pay for. So
By the way, quickly, Michelle asks, do we know any databases where we can purchase contracts? Obviously, one thing that comes to mind initially is like LegalZoom, which I've actually used, and we're pretty good in some things.
yeah, so LegalZoom, I think there's something called InkFile. Oh, there used to be a company.
Mike
Go ahead.
mentions nolo.com here.
Right, Nolo. There's a company that used to be called FormsPass. They changed their name. I think if you Google FormsPass, they'll automatically direct you to um, to their new company. But yeah, there's all these databases. They're going to charge you probably at most $100 for the contracts because they can offer it at that price. An attorney that has to spend their time drafting it, reviewing it, and negotiating, you're going to be charging a lot more because it's going to be tailored to exactly your business. These legal forms are not going to be tailored to your business. So they're going to be better than nothing, but they're not going to be a long-term solution. But again, if you need to look for something, like we just mentioned, those are a few resources for you. So we mentioned before that there's a difference between having a valid contract and and then actually enforcing these contracts. And enforcement comes when there's an issue. Like I said, ideally, you're never going to have to look at the contract because the business relationship is going pretty well. But when a relationship is not going well, then you're going to have to enforce your contract. When you are enforcing the contract, there are certain things that you should be doing, and there are certain things that you should not be doing that puts you in a bad position. So when you have your contract and there's any issues about any term, if there's any questions, anything like that, you want to make sure that clarifications on the terms are in writing, because we talked about that a contract is an agreement between two parties. We talked about that if there's these outside discussions or these outside writings, they may not become part of the contract. The exception here is when you're getting clarifications about terms in your contract, those are acceptable. So there's a difference between adding terms to a contract and getting clarifications about specific terms. It's something that I like to do even when in my personal life. If somebody gives me a contract and I know they won't change the terms, what I like to do is if I have questions about it, I like to send the questions via email. So even if I sign the contract and I'm asking questions via email and they're answering these questions, if there's ever an issue or a dispute, the clarifications can help me prevail if I have an issue, because I'm the one fleshing out terms. And if I'm okay with it, then the result tips in my favor because I'm the one getting clarifications I need and I'm okay with what's being said. If the other side is not okay and they want to stick to the writing, they're going to have a tougher time if we're fleshing out clarifications in writing. So again, we want to make sure that all the agreed terms are in the contract, because if it's not in the contract, and I stress, it may not count. When I say that it may not count, is what I mean is if you have to litigate the issue about specific terms, the other side could win depending on the argument they want to make. Florida law is very convoluted when it comes to certain things, when it comes to what's considered in the contract, what's considered not in the contract. So it's just easier to make sure that if you are forming these agreements with clients, customers, employees, that everything is in the contract. If you have to have extra conversations and new terms are formed, it could be a pain, but it would be well worth it for you to amend your contract or have them sign a new contract with the new terms, because once that gets incorporated into the contract, you're further solidifying the agreement, which basically means that if there is a disagreement, you are more likely to prevail overall. If the other side violates the contract, the instinct may be to reach out to them immediately, but you may want to talk to an attorney first. What you say or do can be held against you. Kind of sounds like this kind of sounds criminal-ish, but it kind of works this way on the civil side. When you're in court, anything that you say to the other side can be used against you as evidence, no matter, regardless of when you say it. So if you're saying things before you're in court, while you're in court, those out of court things that you're saying can be brought into a jury and could end up working against you. So talking to an attorney first at least gives you a game plan and some idea on how you should handle the situation. I'll tell you the most common scenario that happens with the clients with the biggest issues is they will come to us. So something will happen and they will come to us and say, I have this issue. And once the attorney gives them the spiel, tells them this is what I see and here's the price, they think, yeah, I know it's an issue, but I think I can solve it. So, I'll come back to you if things get worse. Then what happens is 3 months later, things get worse. And then someone gets sued. And then now we have to clean up things that were done before litigation, which ends up costing you money in the long run because I got to spend more time cleaning the things up and could potentially put you in a disadvantageous scenario. So basically, the idea is that the attorney is going to help ensure that you don't lose any legal rights. As an example, there's a scenario, I'm going to fudge the details here to protect confidentiality, but I had a client that they were involved in a non-compete issue where my client was accused of stealing clients from a competing company. And those employees had non-competes, so that competing company sued my client. So basically, my client started off the lawsuit in a very good position. And we had some early wins in the litigation. But then I would get emails from my client when I asked certain questions, and long story short, I would find out that my client would have conversations with the other side and had conversations with the other side that we didn't know about before litigation. And those conversations ended up decreasing the chances of us winning. And so we ended up winning anyway, but the idea is that what should have been a slam dunk turned into more of an iffy situation solely because of conversations that the client had with the other side before they spoke to us. So as some takeaways that I hope that you got from our conversations today is contracts have to have 3 elements, and all 3 elements have to be present in order for the contract to be enforceable. And by enforceable, we mean that the contract excuse me 1 second. The poll got in my way. Oh no, it's fine. All right, here we go. Okay. So what we mean by enforceable is your ability to actually get the resolution you're seeking if you have to go to court. Every business should have contracts in place for their product or their services, the people who are working for the business, and for people working with the business. What the titles of those contracts are going to depend on your particular situation. But every business that has contracts, they fall into one of these fundamental categories. No matter what contract you have, you should always have an attorney's fee provision. This one provision can save you tens of thousands of dollars. I actually, to give you an example, we actually just wrapped up a case. It ended up settling, but basically we represented a landlord who's dealing with an issue over a tenant, and the the contract had an attorney's fee provision in there. So which is why we took the case. They were basically fighting over $3,000 or 4,000. It was, sorry, it was about $5,000. They're fighting over about $5,000, but we racked up over $40,000 of attorney's fees. And so the other side started to push, and as time got on, the stakes got higher, higher, and higher, and got to a point where the other side just didn't want to take the risk to go to trial, because we were literally 2 days before trial, to where we told them that we're going to rack up another $40,000 in attorney's fees. Do you really want to do this? And they ended up settling the case. So our client makes out because they are made whole, because now they were at least got their attorney. They got their a portion of their attorney's fees, and they got what they were missing from the other side. And the other side is now has to pay a lot more than they should have paid, because they decided to pursue this and not settle the case earlier when they could have saved some money. Online contracts can be acceptable to use when you can't afford a business lawyer. Like I said, something is better than nothing. But if you're not using a lawyer, your goal should be to one day use one, and don't procrastinate about that, because you're basically sitting on a ticking time bomb, because again, anyone can sue anybody for anything. And make sure your contracts are enforceable in case you have a conflict. So it's not enough that you have the contract itself. You want to make sure you put yourself in a position to where if there is conflict, you have a strong enough contract to get a lawyer on board who believes in you and believes in your case, who believes they can win the case, who can get you a resolution as soon as possible. I like to say that litigation is meant for rich people who like to argue on principle. It is not meant for people who are looking to make a profit, or for people who are hoping to, who can't afford to argue on principle, basically. 99% of cases settle. So contracts and well fleshed out contracts help you settle a lot sooner than later, so you can spend your time getting back to what's most important, which is building out your businesses. With that, that concludes my presentation. I can take questions. I'm not sure where we are on time. I know that Rich has there's more information to be granted to be given to everybody about SCORE going forward. But Rich, if we do have time, I could take some questions.
Oh, well, here's one from Rod. Like rules, Florida Department of State, Florida Administrative Code. Are they actual laws or just interpretation of the law?
That's a good question. What I would say is they're not necessarily. So I'm going to try to answer this in the least complicated ways possible. I would classify them as rules that are based on laws. And so if you violate those, so the laws created these administrative agencies, and so the laws give the administrative agencies the power to do X, Y, and Z, and they articulate their power through the rules. So to bring it full circle, if you violate a rule from any of these departments, you're not violating the law, but violating these rules could have legal implications. I really hope that wasn't complicated or too complicated.
No, that sounded reasonable. You might have to read the question from Cecilia. I'm under Q&A.
Okay.
Take a look at that question.
Uh, let's see. Okay, let's see.
Can you see it?
Yeah, I can see it. Or having a clause like the reception of item X needed
No, I'm going to read it. I may clause like the reception of item X from the client needed to start the project constituting acceptance of this offer. Is this enforceable? Maybe you could explain that
I see.
slightly
Right.
better
Right.
for the
So
folks.
yes. So what Cecilia is basically saying is, as a business owner, can you basically state in your contract that if you perform, so if I give you a contract for a specific set of services, by performing, your performance is telling me that you are accepting the offer and therefore you are binding yourself to the contract. Cecilia, the answer to that question is probably yes. I'm not going to say a clear yes or no, but what I will say is it is definitely possible for that scenario to be enforceable. The laws do recognize what they call it is acceptance by performance. So when you accept a deal, you don't always have to acknowledge it by signing something or paying. Simply performing an act can constitute acceptance, and specifically stating that in the contract makes that clear. So, Cecilia, I would say probably yes.
Okay. All right. So I don't think we have a lot of thank yous from a lot of folks. Sam, that was terrific. Really concise and interesting. Of course, that's why you're one of our most popular speakers. I'd like to thank the City of Oakland Park for their sponsorship of this webinar. For all you out there, go to broward.score.org. I encourage you to sign up for your always free mentoring. On that website, we have recordings, we have articles, we have things of just all sorts of facts and that business owners find interesting. You can see here, go to broward.score.org, and we appreciate everybody attending. And go to broward.score.org to also see the upcoming webinars. We pretty much have one every night of the week right now. We just added some new ones. We're about to. For those of you that are interested in PowerPoint, Excel, and Word, how to become proficient in those software products. So if every business owner at some point needs those. So again, thank you, everybody. Thank you, Sam, and thank you to the City of Oakland Park. And everybody be safe and good night.
Thank you, Rich. Thank you. Thank you, everybody.
Okay, thank you.
All right, perfect.
All right, that was terrific, Sam. Yeah, really good. And oh, we can see you. Okay. Okay, I'm gonna end. I'll give you a call. I'll give you a call.
Yeah.
Bye bye.
All right. Thanks, Rich. Appreciate it.
I'm gonna give you a call right now. Thanks, Sam.
Okay. All right. Bye.